Building on the previous discussion of the doctrine of prior appropriation and the doctrine of water law, it is essential to understand that water rights in Arizona do not automatically transfer with real estate ownership. Unlike land, which is a tangible and immovable asset, water rights are considered a separate legal interest governed by specific state laws, administrative procedures, and in some cases, federal oversight. Whether these rights transfer with a parcel depends on the type of water right, surface, groundwater, or contractual, and the conditions established in the original authorization and deed. Arizona's dual water law system, which separates surface water from groundwater regulation, creates distinct transfer rules for each category. For surface water rights, governed by ARS Title 45, Chapter 1, the doctrine of prior appropriation applies. These rights are not automatically attached to the land. Rather, they are considered usufructuary rights, meaning the holder has the legal right to use water for a specific beneficial purpose, but not to own the water itself. When property with a surface water right is sold, the right does not transfer unless expressly conveyed in the deed and approved by the Arizona Department of Water Resources, ADWR. The buyer must apply to ADWR to have the right formally assigned, and the department must verify that the new use remains consistent with the terms of the original appropriation. For example, a rancher with a surface water right to divert water from the Verde River for cattle grazing cannot automatically pass that right to a buyer unless the deed explicitly includes the water right and the ADWR approves the transfer. If the rancher sells the property without this provision, the buyer would own the land, but not the right to divert the river water, significantly reducing the property's usability and value. By contrast, groundwater rights, such as irrigation grandfathered rights, IGFRs, and Type 1 or Type 2 non-irrigation rights under the Groundwater Management Act of 1980, ARS Title 45, Chapter 2, are generally appurtenant to the land, meaning they are tied to it and transfer with the sale. However, this transfer is not automatic. The buyer must notify ADWR of the change of ownership by filing a notice of change of ownership for grandfathered rights, ensuring that the department recognizes the new owner's legal authority to use the groundwater. Failure to file the notice could result in forfeiture of the right or administrative disputes later. There are also instances where groundwater rights are severed and reserved, meaning the seller retains the right for use elsewhere, often through a separate well or water banking system. In these cases, the right is explicitly excluded from the deed, leaving the buyer without legal access to groundwater on the property. Similarly, if a property is located outside an active management area, AMA, groundwater pumping is governed by the doctrine of reasonable use, which allows the landowner to use groundwater for beneficial purposes but limits large-scale or wasteful withdrawal. This right cannot be sold independently of the land because it is inherent to ownership within that specific parcel, not a transferable permit. An additional layer of complexity arises with Central Arizona Project, CAP, water allocations and contractual water rights associated with irrigation districts or municipalities. CAP rights are typically held under long-term contracts with the U.S. Bureau of Reclamation and managed by local water providers. These contractual entitlements do not automatically follow property transfers and often require separate approval or reassignment processes through the CAP or the managing entity. For example, a commercial developer who buys land served by a private water company cannot assume access to CAP water unless the utility and ADWR approve the new service contract. The reasoning behind this separation is rooted in both law and public policy. Arizona's arid climate, combined with the state's history of water scarcity, requires strict oversight to prevent overuse, illegal transfers, or the speculative sale of water detached from land use. Allowing unrestricted transfer of water rights could lead to hoarding, market manipulation, or environmental harm. Therefore, the state has established procedural safeguards to ensure that all transfers serve a beneficial purpose and remain consistent with conservation goals. In Ernst v. Superior Court, 82 Arizona 100, 1957, the Arizona Supreme Court affirmed that water rights are distinct from land rights, emphasizing that ownership of property bordering a river does not automatically confer the right to use its water. This case reinforced the principle that water rights must be lawfully appropriated, exercised, and transferred through administrative processes, not implied through land transactions. Similarly, the Cherry v. Steiner, 1982, decision upheld the state's authority to regulate groundwater transfers, further solidifying the separation of land and water ownership under Arizona law. For real estate professionals, these distinctions mean that water rights represent a material fact that must be disclosed under AAC R428-1101H and R428-1101I. Licensees have a duty to verify whether water rights transfer with the property, whether they are severed or appurtenant, and to recommend that clients consult a DWR or a water law attorney when necessary. Review summary. Water rights in Arizona do not always transfer with real estate because the state treats them as separate legal interests, governed by complex statutory frameworks. Surface water rights require express conveyance and ADWR approval. Groundwater rights must be formally registered upon transfer. And contractual rights, like CAPI allocations, depend on third-party agreements. The goal is to ensure that all transfers align with beneficial use principles and prevent the misuse or over-extraction of Arizona's most vital resource. Discussion prompts. Why are water rights treated separately from land ownership in Arizona? Answer. Because water is considered a public resource subject to regulation and conservation, not private property that can automatically transfer with land. What must a buyer do to ensure groundwater rights transfer legally? Answer. File a notice of change of ownership with the Arizona Department of Water Resources to record the transfer. Why must real estate agents disclose the status of water rights to potential buyers? Answer. Because they are material facts that can significantly affect a property's value, use, and legality of operations. Closing remarks. In Arizona real estate, the land and the water, beneath or beside it, are not always bound together. Understanding the legal and procedural nuances of water rights is essential for protecting both clients and transactions. As water scarcity intensifies across the Southwest, these rights will only grow more valuable and complex, making it critical for professionals to maintain up-to-date knowledge of water law and disclosure obligations.